Joint Tenancy Part 1 Application of MUIS Initial Fatwas on Joint Tenancy. This presentation is based on research and books written by Sadali Rasban on the main challenge faced by Muslims in Singapore on estate matter, joint tenancy upon death of a joint tenant. You will have some understanding what is joint tenancy from the state law. You will also understand in greater details of joint tenancy from MUIS perspective. Ultimately, you as Muslim should decide to accept joint tenancy or to agree with MUIS fatwa and reject joint tenancy. Objective: this presentation will help the viewer to understand the history of joint tenancy challenges in Singapore. It started from these initial fatwas. We will also discuss about MUIS initial fatwas issued to the Muslim. There is no intention to discredit those fatwas, but merely to understand the consequences in the implementation or the rejection of the fatwas by some sector. MUIS initial fatwa. Two initial fatwas were printed by MUIS on joint tenancy sometime in 1998. The Fatwa FAQ 57 and 58 from the Book of Fatwa 3, first edition, page 38. Question 57. Can a flat bought by a man with his ex-wife under joint tenancy be completely owned by his ex-wife when her ex-husband passes away? MUIS response. After extensive research on the joint tenancy position, the Fatwa Committee believed that the ex-wife is not the rightful owner of the said flat. The Fatwa Committee concludes that the ex-wife of the deceased is only entitled to 50% of the value of the flat. The share accrues as virtue of ownership as joint tenant, co-owner. The other 50% will be the deceased estate and to be disposed based on the faraid. The ex-wife will have no share from this 50%. This statement confirms that MUIS defined joint tenancy among joint tenants as equal share among the joint tenants. Upon death of a joint tenant, 50% belongs to the deceased. The other 50% belongs to the surviving joint tenant. Such definition is not in accordance with the concept of equal interest in joint tenancy. Question 58. A couple bought a HDB flat as joint tenants. According to HDB rules, if one of them passes away, the house will be owned by the survivor. What is the Islamic law on this matter? This is the most common situation in Singapore for a couple to own a home. HDB is a public housing scheme that is in accordance with the Singapore government public policy to ensure every family have a home, even upon death of one joint tenant. MUIS response. The Fatwa Committee made a decision that the house which was bought as joint tenancy cannot be owned fully by the surviving partner. The share of the deceased will be valued and then distributed among his legal heir according to faraid. This fatwa shows that MUIS reject the joint tenancy contract of survivorship. It also confirmed that the equal and undivided interest by joint tenant in joint tenancy property is been defined as share owned by each joint tenant. MUIS fatwa seems to determine that each party will have an equal share, 50-50, to the joint tenant property. It is important to know that equal and undivided interest is not equal share. It also confirms upon death of one joint tenant, the joint tenant property need to be split among the deceased legal heir and the surviving joint tenant. Justification of the fatwas. Doubt in the contract. Two factors create doubt in joint tenancy. Number one, right of survivorship. MUIS argue that the survivorship agreement in joint tenancy contract is not Sharia compliant. MUIS argue that there are only three means of transferring the deceased shares in joint tenancy property upon death. A. By means of inheritance through the Faraid system. MUIS seems to define that Faraid is the Muslim law. That is, Faraid is the reference to all wealth estate distribution process. It seems that anything that is not in line with Faraid is not in accordance with Muslim law. By means of Nuzriya, as agreed by the Fatwa Committee. Nuzriya is a special tool that is only used in Singapore and not in the neighboring countries like Malaysia or Indonesia or other countries. It allows a person to give away any amount to anybody 3 days before his death due to sickness or 1 hour before his death due to sudden death. This special tool has been rejected by the Singapore High Court. The Singapore High Court have categorized this special tool as a Muslim will wasiyah. It can only be given to those not getting from the Faraid, and the amount cannot exceed 1/3 of the net estate. By means of wasiyah will drafted during the deceased lifetime, wasiyah is a well-established tool. Two, Gara, uncertainty. In a contract of joint tenancy, the co-owners have equal and undivided interest in the property, but the proportion of the shares among co-owners is not clearly defined. This means that there is no exclusive ownership among the co-owners of the property. This creates gara, uncertainty, in the contract based on Muslim law. Thus, such a contract must be rejected. Implication to the initial fatwas. Most widows were advised to adhere to the fatwa by selling the home and distribute the share to other legal heirs. They were advised to dispose immediately as requested by the other legal heirs. Such advice came from MUIS office, other Muslim bodies, religious teachers, and even Muslim lawyers. Such advice does not come with assurance that the widows and the children's well-being be cared for. Such implementation took away the shelter, honor, wealth, and family unity. Are these the objective of Sharia? Opportunists who are irresponsible use these fatwas on the weak and needy widows for their personal greed, not to enforce Muslim law, the Sharia. Very rare widower is advised to adhere to the fatwa. There seems to be some injustice imposed on widows by those Muslim advisors. The fatwas seems to be used on the weak and needy with no intention to accomplish the objective of Sharia. HTHT's response. Sadali Raspan, founder of HTHT, decided to do research. Sadali was approached by several widows who documented their plights on the fatwa on joint tenancy. Books and articles in English and Malay were written, and many talks on this subject were conducted by Sadali Raspan. This book can be found in Singapore Library. The title of this book can be seen in our website, hcht.com.sg. Please tell your friends and relatives about this presentation and proceed to the Joint Tenancy Part 1 presentation on MUIS latest fatwa and their implication.